Good evening, friends. Welcome to today's session on salient features of Constitution. Just a brief recall of the earlier sessions we had in the past 3 days. The first session, of course, was on the understanding of law. Second, on the understanding of governance and various systems of governance. Yesterday's session was primarily on making of the Constitution and how it evolved and took its present shape as we have now, starting from the British days uh, till the present day Constitution. Now, having gone through this process, first understanding the law, second the understanding of various forms of governance and which form we have adopted in India, that is the Democratic Republic, and then how our Constitution has been made, how it has been enacted, adopted, came into force. Now we are going one step further to understand the salient features of the Constitution. What do we mean by salient features? No, these are some of the essential features which a student of constitutional law must understand to have an overview what this constitution is meant for, what are its various provisions in a nutshell, just to its ideology, its philosophy. What does it want to provide? Okay, we will study all these organs, all these provisions of the Constitution in a detailed manner when we start our regular, study of the syllabus as per the syllabus. So these are only to take you a step towards that, make you understand the basics. So these are basically the basic features of the Constitution, which we will be discussing today. This will definitely help you in the polity examination, polity part of your general studies paper, tremendously. I tell you, because these questions, whatever we have studied in the last 3 sessions, is going to help you a lot in your preparation for general studies paper. Plus, the main focus, of course, will be on law optional of the civil services examination, because we are aiming for that. You all are, you have joined me as your guide. You have taken me as your guide for that purpose only. But I want to make you understand the basics of the Constitution, the legal framework, the framework of governance, so that you are well prepared to take on the tougher task of, uh, reading, studying, and understanding, taking your level of understanding to that level where you are able to, take this examination and come out successfully. So let's start today's session. What are the factors? Yesterday when we were discussing about the making of the Constitution, we had found that ours is the largest, the longest Constitution in the world. So people, the critics call it, elephantic size of our Constitution. It's a huge in size with more than 400 articles, with 12 and 25 parts like that. It's a huge document as compared to all other constitutions of the world. So what has led to the constitution makers opt for such a huge, supreme law of the land? So let us analyze one by one what are those factors, so which have contributed to its such a large size. The first thing is the geographical factors. Now, what are the geographical factors? Ours is a huge country in terms of size, in terms of population, okay, in terms of diversity of linguistic diversity is there, cultural diversity is there, racial diversity is there. But what brings us together as Indians is the Constitution. So our Constitution had to take into consideration all those factors which are there because of the huge territorial size, the geographical size of the country. Even the racial characters are different. We find in the south we have the Dravidian race, we have in the northeast the Mongolian race, we have in the north we have the Aryans race, and other mixtures, other blends of various races. The language changes so fast territorially. If we move from one territory to another, after a few kilometers, you will either find a new language or a new dialect. This may be the same language but spoken in a different dialect. There are, similarities, there are differences between the languages. So, such a diverse culture is there. The culture, even the eating pattern, the food habits, they are different. The clothes we wear, our outlook is different. Our beliefs are different. Our religions are different. So all these factors led to adoption of everything which can fit into this diverse culture and unify it into what? Into a union of India. And that Indianness is very important for us. In spite of this diversity, we are all Indians and we are proud Indians. And that Indianness, that sense of nationalism, binding character comes through this beautiful document, the Constitution of India. So its various provisions took into consideration these geographical factors. Now, as we discussed yesterday during the making of the Constitution, that a large portions of the present day Constitution, or when it was enacted and adopted in 1949 and then came into force in 26 January 1950. Now, a major influencing factor was the Government of India Act 1935. We call it a mini constitution also, but this was given to us by the Britishers. So this was the influence, because this itself was a huge document. So it was, it definitely added to the size. Now we come to the single constitution for both center and the states. Though ours is a federal system, we have adopted a federal system where states are the units of the union. Now, there is a single constitution which governs, applies to both center and the states. There are no separate constitutions for any constituent units or the territorial units. That is the states. So both the states and the center have one single constitution, and we have 29 states. So that is why if had we got different constitutions or mini constitutions for the states, the size might have been smaller. But we have a single constitution which has to take care of the needs of the states and various forms of the governance of those states. The center-state relations, very important part. So that itself has contributed to its large size. Whereas, the first parts like fundamental rights, directive principles, fundamental duties, etc., they can be clubbed like part 1, part 2, part 3, part 4, and part 4A. Now, these parts, 5 parts of the Constitution, are generally, applying to the entire India. Okay. In what? The entire Constitution governs the governance of the entire country. But what I am talking about is the common features. Now, these 5 parts contain certain, provisions which can be applied universally, commonly, which do not much affect the center-state relations. But when we come to like president, governor, chief ministers, central government, state legislature, parliament, we have different constitutional authorities, we have judiciary. So all these things have effect on the center-state relations. So that is why, a single constitution had to contain all these provisions, and that contributed to its large size. The dominance of legal luminaries in the Constituent Assembly. See, yesterday, while talking about the making of the Constitution, we had seen that, very primarily the members of the Constituent Assembly who contributed and which led to the enactment of our Constitution, they were lawyers, politicians. If you remember, we had discussed this point. Lawyers, politicians. So they were all legal luminaries. The chairman of the drafting committee, the members, most of them were lawyers, barristers. And they had the legal background. Because it was they were enacting what? They were not enacting a small law. They were enacting the supreme law of the land, the Constitution. So that is why it was dominated by legal luminaries. So that also led to its large size. Because there were so many inputs, legal inputs. Every legal aspect had to be examined, as we had seen yesterday during the process. The clause by clause reading was done, analysis was done. So many readings, first reading, second reading, final reading, like that, it was done. So each and every word had to be analyzed on legal issues so that we do not create a document, create a law which will lead to any legal, problems or litigation later on. To avoid all those, situations, the legal luminaries took care of each and every legal aspect of every provision of the Constitution. That is why it led to its large size. Now, some of the salient features, now we'll take the individual salient features. One is the lengthiest of all the written constitutions of the world. It is the lengthiest written constitution. Now let us see once again. Written constitution is in USA. Unwritten constitution is in UK. So what it contains, what is the size, how many articles, how many parts are there, how many schedules are there. When it was enacted and adopted in 1949, November 26, 1949. So the original constitution had a preamble, 395 articles divided into 22 parts and 8 schedules. Now, in the present form, it should be in fact 2020. It has a preamble, 470 articles divided into 25 parts and 12 schedules. And there have been so far 104 amendments. So by way of amendments, what has happened? Some portions have been added, some provisions have been added, some have been repealed, some have been modified. So this is how it makes the Indian Constitution the lengthiest written constitution of the world. Now, yesterday also we had seen the various sources of the Constitution. From various sources, we have adopted the best possible features. We have picked up the best features, and we have adopted to our own local Indian conditions because of the diversity of the country and our own needs. So, what the British Constitution provided, what features we have picked up from there is the parliamentary form of government, rule of law, law-making procedure, single citizenship, institution of speaker, doctrine of pleasure, tenure of civil servants. Now, I will briefly explain to you all these terms because these terms will be studied in detail when we take up the individual topics for our law optional syllabus. So, the first thing is the parliamentary form of government. That means we have a parliament consisting of two houses, the Lok Sabha and Rajya Sabha. Okay, so like in UK, we have House of Commons and House of Lords. House of Commons is like our Lok Sabha and House of Lords is like our Rajya Sabha. So that format we have adopted. Okay, so we have a parliamentary form of government. Rule of law is very important. Just to understand it, remember it is the supremacy of law. Law is supreme. Nobody is above law. Just remember this much for the time being. Supremacy of law. And nobody, whosoever high he may be in terms of in the hierarchy or in terms of his position, is above law. Law is same for everybody. So, and law is supreme. This is the simplest meaning of rule of law. So, law-making procedure, how laws will be made, like bills are introduced, bills are passed by both the houses, president's assent is obtained, and in some cases even the bills will go to the respective at least to the state assemblies, and at least half of the states must ratify that. Okay, so that will come when we study the amendment of the constitution is one part, and in the case of making of law, that is the basic job of the legislature. So how laws are made, when we study the functions of the legislature during our syllabus discussion, we will be studying in detail at that time. We have single citizenship as compared to like dual citizenship in the case of USA. So we have single citizenship. There are no different citizenship of the union and of the respective states. Though we are having a federal, structure of governance, but still we have a single citizenship that has come from the UK. Institution of speaker. Now we have a speaker for our Lok Sabha and we have the chairman of the Rajya Sabha. Now, who is the chairman? Chairman is the Vice President of India. He is the chairman of, he is called chairman, not speaker. Speaker is for Lok Sabha. Okay, he is the chairman, Rajya Sabha. So, institution of speaker. Doctrine of pleasure, we will be discussing it when we discuss the services under the union. We have all India services like Indian Administrative Service, Indian Police Service, and Indian Forest Service. So we will be studying. Doctrine of pleasure means that a civil servant will hold the office according to the pleasure of the president. Pleasure of the president, that is the as long as the president wants, or in other terms, in the more simpler terms, the government wants. So, as long as that pleasure is there, the civil servant will continue. Once that pleasure is removed or stopped, the person will not be eligible to hold that office. So, doctrine of pleasure, in case of civil servants, we will be studying under Articles 309 to 3012 or so in detail. So, in that case, this doctrine of pleasure will come, but this feature has been picked up from the British Constitution. British Constitution, again I am repeating, is unwritten. So, in the unwritten constitution, the conventions are very important. So, these are the conventions which are followed by the British Parliament. From the American Constitution, we have adopted the judicial system and the fundamental rights. Very important parts, both of them. Fundamental rights are our basic rights, and which a human being must have in a free, independent, sovereign nation. Okay, so at judicial system we will study, but more or less it is like we have a federal court that is called Supreme Court of India. We have high courts in the states, and we have district courts, and below them are the small courts. So these judicial system, it is slightly different in America from ours, that we will see when we move little further. But the system has been obtained, has been picked up from American Constitution. From the Canadian Constitution, the federal system, union-state relations, and distribution of powers between union and states. This again, the federal system we will study, the union-state relations we will study, and how the powers are distributed. Okay, so we have like three lists: the union list, the state list, the concurrent list. This is basically division of powers, separation of powers between the union and the states. So, but the concept of concurrent list has been obtained from another constitution, but basically the distribution of powers is from the Canadian Constitution. The Irish Constitution is another important part, directive principles, and how the elections to the post of president of the country will be conducted. From the German Constitution, we have the emergency provisions. We'll study them. From the Soviet Constitution, we have the 5-year plans. We have the fundamental duties. From the South African Constitution, amendment of the Constitution. Now, Government of India Act 1935, which I just referred to as a mini constitution of the British time, was the federal scheme, judiciary, governors, emergency powers, and the public service commissions. Okay, so let's proceed further. Now the question comes, how rigid is our constitution and how much flexibility is there? What do you mean by rigid constitution? Rigid constitution is one which is, if it is truly rigid, it's almost impossible to change it, amend it. And if it is too flexible, then it can be changed easily. So we have not adopted any of these two extreme conditions. What we have adopted is a blend of the two. How? Let us see the rigid constitution, one that requires a special procedure for its amendment, like in the case of American Constitution. It's very difficult to amend it. Okay, the amendment procedure is very difficult. And the flexible constitution is one that can be amended in the same manner as any ordinary law. See, mind you, the difference between constitution and an ordinary law is that constitution is the supreme law of the land. It is the fundamental law of the land. It's the highest law. No law is above constitution. But when we talk of ordinary laws, there are hundreds of ordinary laws. Hundreds are being made, being repealed, being amended. New laws are coming almost every now and then. So, to make laws, ordinary laws, is very easy process. But amendment of the constitution or changing the constitution, particularly if it is a written constitution, is very difficult. It's not that easy as making ordinary law. So it is not like that. So why British law? Why British constitution? Because it is unwritten. So if it is unwritten, it is flexible. It can be easily amended. So our constitution is neither rigid nor flexible, but a synthesis of both. How? We will see under Article 368, which deals with the amendment of the Constitution. Though under this article and as interpreted by the judiciary, the Parliament can amend any part of the Constitution. Earlier there were different interpretations through various judgments, which we will study in detail, as to like some parts cannot be amended. Okay, and some parts which were put in the 9th schedule could not be amended. But now no such restriction is there by way of judicial pronouncement in the landmark case of Keshwanand Bharti. But a very big rider has been put, that is that of the basic structure doctrine. So any part can be amended subject to its passing the basic structure doctrine or criteria. So it is neither rigid nor flexible, but a blend or synthesis of the two. So let's come to that. Article 368 provides for two types of amendments. One is a special majority of the parliament is required. They call it two-thirds and two-thirds of the present and voting. So that is a special majority. We'll study that in the constitution. Some other provisions which require the special majority of the parliament and the ratification by half of the total state assemblies. I have just mentioned that. And some can be passed by simple majority of the parliament. So basically two forms. This is simple majority is for making the ordinary laws. These two are for constitution. Primarily. We'll get into the details. I'm just giving you an overall view of the salient features, not telling you the detailed provisions. Detailed provisions we'll be studying when we take up those topics during our study of the syllabus. Now, ours is called a federal system with unitary bias. This we will study when we do the federalism. But for the time being, the federal features are that the units, that is, in our case, the states, they join the union. Join what? The union. Now, this joining is not by way of any agreement or a treaty. Once they have joined, they cannot secede. They cannot get away. They cannot go out of this union. So, this joining is of the union by the states is a federal character because they are different units and they have given some kind of autonomy. Okay, when we study union-state relations, we'll see how much autonomy has been given to the states by the union. So it has a unitary or non-federal features also. That means the central list, the appointment of the president, these kind of unitary features are there which are more oriented towards the center, which give more power to the center. So there are unitary or non-federal features also. We'll study it on our session on federalism. So, but ours is what? Ours is having both. That is why some people call it a quasi-federal structure. Right? Because it has got both. So, this is what Weare has said, quasi-federal. It is a bargaining federalism. Bargaining means between the two units, the center and the state, the bargaining for having more powers. Cooperative federalism, this question has come in the papers, in the civil services examination. The quasi-federal, the cooperative federalism, bargaining federalism. So these we will study when we study federalism, but for your basic understanding, for the purpose of, general studies polity part, cooperative means they are more cooperating with each other. It's not conflict. It's not leading to conflict. It's not conflicting federalism. They are working in tandem to maintain this character of federalism. So, federalism with a centralizing tendency. This is what I said, with unitary bias. Okay, so these are the four important observations by the jurists. We have to remember them because they can be asked in the question, in the examination. We have the parliamentary form of government based on the principle of cooperation and coordination between the legislative and executive organs. Now, what are these two organs? It's very important. We call it a Westminster model of government, which is from the UK. So, there is a responsible government and cabinet government. That means we have a cabinet and a council of ministers who are actually conducting the executive function. Below them is the executive. And they are responsible to whom? They are responsible to the parliament, more particularly to the Lok Sabha. So that is why we have a system, a model of government which is both responsible and having a cabinet form of government. We also can, as when we compare it with the parliamentary system, we should know the other system also, that is the presidential system, which is there in the USA, where both the legislative and the executive organs are concentrated or are joined in one authority, that is the president. In our case, what we have a constitutional head. He is the President of India. In the states, we have the constitutional head of the state, who is the governor. But on the executive side, we have the executive, that is the Council of Ministers, headed by the Prime Minister. And in the states, we have the Council of Ministers, headed by the Chief Minister. So they are the executive heads. We have the legislative heads. So they are, different entities, but in the presidential system, both are same. Now, features of the parliamentary government: presence of nominal and real executives, majority party rule, collective responsibility of the executive to the legislature. That means the executive is responsible to the legislature. This is what I said. The collective responsibility is towards the legislature, towards the parliament. So the executive has a collective responsibility to the legislature for all their actions. Why? Because legislature makes the laws and the executive has to implement them. And so they are the lawmakers. Legislature are the lawmakers. So those who implement the law have to be responsible to the lawmakers. So leadership of the Prime Minister or the Chief Minister, Prime Minister for the Parliament and Chief Minister for the state legislature in the states. Now, dissolution of the lower house. This is a very important feature of the parliamentary form of government. Please remember that only the Lok Sabha or the state legislature can be dissolved as per the provisions of the Constitution, not at the whims and fancies of any authority, but as per the provisions of the Constitution, which we will study later. But just remember that only the Lok Sabha or the State Assembly can be dissolved, not the Rajya Sabha. Please remember this. Only the Lok Sabha. So, what is the parliamentary sovereignty and judicial supremacy? Both these terms are very, very important. It is basically, we can say in a rather layman's language, who is supreme? Is it the legislature who is supreme, or is it the judiciary who is supreme? Legislature makes the law, judiciary interprets the law. Both, I should say, this is my own observation as a law student, both have supremacy in their respective areas. How? See, you might have observed that sometimes a question is raised before the issue comes before the Supreme Court, where there is a need for a new law. Okay, a situation comes where it is felt that there is no law which fulfills, which addresses that situation. No law on the statute. So in that case, it is not that the judiciary takes the responsibility of making the new law to fill up that gap or to address that situation. They simply say it is the job of the legislature. Please go to legislature and get a new law from there. Our job is only to interpret. And during that interpretation, through the case decisions, some aspects of laws emerge out of it, and we call it the judge-made law. Though truly it is not made by the judges, it is through interpretation. Some facts or some aspects of that law which were not earlier known to us or which were not applied so far have now been applied through their interpretation. And that takes the form of a new law, but in reality, in actual terms, it is not a new law. It is just the interpretation of an existing law. And they are completely independent. In the case of judicial review or interpretation of laws, our judiciary is completely independent. They are not working under legislature or they are not working under the executive. For their decisions, they don't have to take directions from anyone. It is their own independent interpretation. And that is why we say that we have an independent judiciary. So, but who is supreme? Is it the judiciary who is supreme or the parliamentary? Parliament is sovereign in many aspects. How? Parliament can take any decision collectively, of course, which affects both the internal as well as external functioning or the matters of the government, of the state. How the nation is to be run, what laws should be there, what should be permitted and what should not be permitted by way of law is decided by the parliament. There they don't have to take any direction or instructions from anybody. If there is if a need is felt in the society that there is a need for a new law or a different law or a law which is not fit for the present circumstances, present times. So in that case, that law has to be changed or a new law has to be made. There the parliament is sovereign. There they have the supremacy. But when it comes to judicial supremacy, they are supreme in their own functioning. So both are supreme in their own functioning. This is how your answer should be. If a question is asked, who is supreme? Whether parliament is sovereign and supreme or the judiciary is supreme. No, they are both supreme in their own spheres, in their own way of working, because there is a complete separation of powers. There may be some, overlapping here and there, But as far as their basic job of, making the laws and interpreting the laws, both are supreme in their own spheres. Now, doctrine of sovereignty of Parliament is associated with the British Parliament because they can make any law. And principle of judicial supremacy is with respect to American Supreme Court, where the court's decision is final. So they can strike down, they can create a new law through their own judicial, pronouncements. But not in India. Yes, here we have the independent judiciary. They are supreme in their own functioning. Now we have the integrated and independent judiciary. There is a single system of courts which enforces both the central laws as well as the state laws, unlike in USA. Now, what is the position in USA? They also have a federal court, that is the Supreme Court. But Supreme Court will not rule on the state laws. That is left to the state judiciary because they have a truly federal system. The units in the federation have got more autonomy as compared to what we have in our federal system. There, the states have more rights, more autonomy. And the state judiciary also has got more autonomy as compared to our state judiciaries, like high courts or lower courts. There, the matters relating to state laws are finally decided by the state judiciary. They will not come to the Supreme Court. Supreme Court will deal with only the federal laws. So the scope of judicial review, the power of the Supreme Court in India is narrower than that of what exists in USA. How? Because in American Constitution, there is a due process of law. See, these two terms, due process of law and procedure established by law, we will be studying in detail when we study Article 21. What does Article 21 say? Article 21 says that nobody will be deprived of his life or personal liberty except according to procedure established by law. Procedure established by law has got a limited scope. There must be a law, there must be a procedure. And if that procedure is followed, then you can take away the life and or liberty. That was the original provision, original interpretation. Provision is same, but the interpretation prior to what case? Prior to Menaka Gandhi case, that was the situation. That there must be a law, there must be a procedure. But now, and in the case of due process, the judiciary can examine any aspect of that law, that process of law. Whereas, after Menaka Gandhi case, there are only three factors which have to be examined. One is that procedure has to be fair, procedure has to be just, and the procedure has to be reasonable. Now, this has led to some kind of semblance with due process. People say, the jurists also say, or the people in the legal profession say that the due process of law has entered the Indian legal system by a back door through these terms in the Menaka Gandhi case. But this, if you see, when we will study in detail, you will feel that this is only a limited type of due process. Due process is a much, much wider term. It can, look into any aspect of the process. But in India, after Menaka Gandhi case, it has to be tested only on these three touchstones. So here the Supreme Court is a federal court. It is the highest court of appeal. The final appeal lies with the Supreme Court, guarantor of fundamental rights of the citizens. Article 32, judicial review is there. The guardian of the Constitution. Now here there are two. One is that Article 32 for what? Judicial review. What do you mean by judicial review? Judicial is by the judicial process, by the judiciary. Review means if any action is there, any law is there, any executive order is there, any executive action is there, it is subjected to a review by the judiciary. Judiciary will decide whether it is adversely affecting the fundamental rights of the citizens or not. That is under Article 32. It is also one of the fundamental rights. Guardian of the Constitution is, after Keshwanand Bharti case, as I said, that any part of the Constitution can be amended, but subject to what? Basic structure doctrine. So that means if the Parliament decides to change the fundamental or the basic structure of the Constitution and passes such an amendment or a law, that can be struck down by the judiciary, the Supreme Court. Because if it is violative of basic structure, if it disturbs the basic structure of the Constitution, it can be declared as void, can be removed. It will not have any effect. So this is how it is the guardian of the Constitution. Now, the constitutional provisions are to ensure its independence. How? Whose independence? The independence of the judiciary. Security and fixed service conditions of the judges. That means the judges cannot be removed so easily. There is an impeachment process which has to be followed. So there is a kind of a security and the fixed tenure, fixed service conditions which are provided to the judges. That leads to that is one aspect of the independence of the judiciary. Now, their expenses are met from the Consolidated Fund of India. We will study this when we study that part of the Constitution. It is basically the Consolidated Fund is where all the revenue comes and all the expenditure is incurred. So, from that Consolidated Fund, the expenses relating to judiciary are spent. That gives another form of security and independence, because for the funds, for meeting their expenses, they don't have to look for other sources. There is one single source, that is the state, through its consolidated fund. So there is prohibition on discussion on their conduct. Where? By the legislature. That means their conduct cannot be discussed in the parliament or in the legislature. This is a prohibition on the legislature by the Constitution. Now, there is a separation of judiciary. That means judiciary is not to be controlled by either executive or by the legislature. Ban on practice after retirement. They cannot practice as an advocate in any court once they retire as Supreme Court, judge of the Supreme Court. They can be appointed by the government to some post, like, they have been posted as governor of a state. One Chief Justice, Justice Sadasivam, was posted as the governor of state of Kerala. Recently, the former Chief Justice of India, Justice Ranjan Gogoi, has been made the Rajya Sabha Member of Parliament. So, that is not a ban. There is no prohibition on that. But they cannot practice in any judicial forum. Okay? So, separation of judiciary from executive. Executive have no control over judiciary. Now we come to the fundamental rights. In part 3, there are basically 6 main fundamental rights. Right to equality, Articles 14 to 18. Just I am giving you a brief picture of that. Right to freedom, Article 19 to 22. There are 6 freedoms in Article 19, and 20, 21, 21A, 22 are, giving different kind of protections. Right against exploitation, Article 23, 24. Right, freedom of religion, 25 to 28. Cultural and educational rights, 29 to 30. And right to constitutional remedies, that is the judicial reviews, 32. These are all fundamental rights. That means they cannot be denied to any citizen. And in some cases, even to non-citizens also. Now, a very important term which is generally asked in the general studies paper is the types of writs. Writ is an order from the highest court or by the high courts, either by the Supreme Court or by the high courts. Writ is an order. Now, order are, basically there are 5 orders. They are called, one is called habeas corpus. Its literal meaning is to have a body, to have or to produce a body. That means a person, human being who has got a body like you and me, I cannot be deprived of my living, my existence. That means if I am detained illegally, I am not free, my liberty is curtailed, my life is taken. Okay? In that case, the highest Supreme Court or the High Court may issue a writ of habeas corpus giving direction to the authority that you produce his body. That means he should be in existence. He should not be in any kind of illegal custody. So, if person's liberty has been taken away, that means his body has been, confined somewhere, or there is a, restrictions on its movement of the body. In that case, the writ will be that, okay, you justify that restriction. Why you have done this? Produce that body, produce that person, produce that human being. That is the habeas corpus. Mandamus is a direction to the executive to do. To do what? Suppose an executive authority is entrusted with a public duty to perform, and they fail to do that. In that case, the highest court, the Supreme Court or the High Court as the case may be, Supreme Court under Article 32 and High Courts under Article 226 of the Constitution, they will direct that authority to do that duty with which they are entrusted with. So to do their duty. So this is a direction to the executive. Prohibition. It is just opposite of this to do, not to do. That means if they are doing some act which is beyond their powers, ultra virus of their powers, they are not authorized to do something. Law does not permit it. And by doing that, they are infringing into the fundamental rights of, violating the fundamental rights of a person, of a citizen. In that case, the court will have to stop them. Don't do it. Mandamus was to do, you do it, and prohibition is not to do it. Certiorari. Certiorari is to produce the records. What records? Now we have seen that we have the Supreme Court, we have the High Court, we have the lower courts below them, and there are other quasi-judicial authorities, tribunals, who take, and other executive authorities who take a number of decisions every time. For any action, they take certain decisions. And all executive decisions or the judgments or the orders or the directions, instructions are in the written form. They are recorded. Okay? So those records can be called up by the Supreme Court or the High Court that you produce those records. On what basis you have taken that decision? So that records pertaining to that decision, executive decision or a judicial decision by a lower authority, a subordinate authority, can be called for by the Supreme Court or the High Court. I'll just write here. Supreme Court, Article 32, these writs can be issued, and High Courts, Article 226. So they are given the powers to issue these 5 writs. So they give these kind of directions, right? The last one is quo warranto. This means under what authority? Now, there can be various situations, but I'll just mention 2 major: holding an office and exercising the authority. What does it mean? Suppose there is a post which has got certain amount of authority. Okay? Some person, some officer or some person, I will say, not even an officer, is holding that post. Now, through quo warranto, the court, either of these 2 courts, can ask that authority, under what authority, what permitted you to hold this post? If I am, suppose like I am the deputy commissioner of a district, collector of a district. So under what authority? Who is the appointing authority? Who has appointed you to this post? Of course, if the state government has appointed, they have the authority. They must have issued an order. Suppose there is no order, and if I go and just sit on the seat of the deputy commissioner or the district collector, I am not entitled to that. I am without an authority. So, under what authority you are holding that office? And then, under what authority you are exercising the powers and authorities attached with that office? Suppose, as a district collector, I have not been appointed by the state government or the competent authority, but I pass certain orders under section 144. I declare that not more than 5 persons will be allowed to gather here, or I issue an order of curfew or some other restriction. So the court will ask me, from where you got this authority? Under what authority you have issued this order of 144? So these are the 5 writs. Please remember, these will be again taught to you, discussed with you when we study Article 32 and the writs. But this is just for your general understanding of what these writs are. I try to make them very simple: to have a body, to do, not to do, you are prohibited, stopped from doing that. Then to produce the records, certiorari, and under what authority. Okay. Now, the fundamental rights promote the idea of political democracy. That means, as we have already discussed, democracy means the rule of the people. So, the people have to be given certain fundamental rights, the basic rights. Operate as limitations on the tyranny of the executive and arbitrary laws of the legislature. That means executive is not given a free hand. The legislature cannot pass arbitrary laws, and the check is through fundamental rights, because if the fundamental rights are violated, there is a process of judicial review. Justiciable in nature, enforceable by the courts for their violation. Very clear? They are not absolute. This is very important to understand. Absolute means they are not unfettered. If you have got a freedom of speech, can you speak anything what you want? If your fundamental right is there, 19(1)(a). This is a freedom given to us, to the citizens. That, what that freedom is? Freedom of speech and expression. Now what happens? Under this freedom, if we start abusing somebody, defaming somebody, that will not be permitted. If we are given free hand to speak anything or express ourselves in any manner, that will not be the true freedom, though it will be an absolute freedom. But nothing is absolute in democracy. We have to take care of the others' rights also. So in that case, reasonable restrictions are there under Article 19(2). These are all subject to reasonable restrictions. Now, what are those reasonable restrictions? Like defamation. Don't defame anybody. Don't utter anything. Don't write anything and defame the other person. In public security, in the national security, you cannot utter anything which is against or which is affecting the national security. So all these restrictions are given in 19.2. So these two have to be read together. They cannot be read in isolation. 19.1a cannot be read in isolation. We take the case of 19.1g. You can have any profession, you can do any business. But then the reasonable restrictions are under 19.6, which say that if you are having a profession, you must, the state can impose or put certain conditions as to what qualifications you should have. If you have to practice medicine, you must be a qualified doctor. If you have to work as an engineer, you must be having a qualification as an engineer. You want to work as a lawyer, you must have the legal, you must have passed you must possess the legal knowledge, the professional knowledges. And the state may also create a monopoly that state will be only doing this, like railways. Okay, state will only run the railways. You and I cannot run a railway. So that kind of restrictions are there which are in the interest of the nation, which are in public interest. Okay? And they can be suspended when during a state of emergency, except 21 and 22. Except these two articles, other fundamental rights can be suspended during the state of emergency. Now we come to Directive Principles of the State Policy in Part 4. There are basically three categories. One is the socialistic, Gandhian, liberal, intellectual. Now, socialistic belongs, we have seen the socialist word has been added in our preamble also by 42nd Amendment. That means there should not be concentration of wealth in few hands. That means there has to be an equitable distribution of the resources of the nation. Income, money should not concentrate, wealth should not concentrate in few hands. So that is the aim, that is the purpose. Gandhian means there should be like a system of governance which should flow from down above, like the panchayati system, the legislature, state legislature, and the union legislature. This is how the Gandhian structure is there. We will come to the question as to how much is there and when it was introduced little later. Liberal and intellectual. Now, I tell you one important thing is that these are all duties. Duties or responsibilities of the state. In the case of fundamental rights, they were the rights. As I tell you, every time that law creates both rights as well as creates duties. So, same way, Constitution of India also creates certain rights for us in the form of fundamental rights, and it casts upon certain duties on the state in the form of directive principles of the state policy. What is the aim? Aim is to have a welfare state. During the British time, we call that period as a police state. What do we mean by police state? That means an oppressive state, where the welfare of the people is not so important, but the welfare of ruler is, who is ruling us. That was important. His interests were more important than the welfare of the people. But after independence, in a democratic setup, the aim is to have a welfare state where welfare of the citizens of the state are more important than the welfare of the rulers. They are non-justiciable. That means you cannot go to the court for enforcing them. Okay? They can, like fundamental rights. Fundamental rights are justiciable. You can go to the court for their enforcement, but not in the case of directive principles. The important case on this, just for your references, sometimes it is asked, is the Minerva Mills case, in which they said the Indian Constitution is founded on the bedrock of the balance between the fundamental rights and directive principle. That means the balance between rights and duties. So a balance has been tried to be obtained or made by the Constitution of India. Now, these fundamental duties were added by 42nd Amendment Act, and they are also in the form of duties, but these duties are on the citizens. See, same principle applies. The citizens have been given certain rights in the form of fundamental rights. Now, on the duties side, there are two aspects. One is the duties cast upon the state. The state should do this to have a welfare state. And in the case of the citizens, the duties are, basically on to respect the Constitution, respect the national flag, national anthem, protect the sovereignty, unity and integrity of the country, promote spirit of common brotherhood, and preserve the rich heritage of our composite culture, and so on. So this part 4A was added by the 42nd Amendment, and there's one single article with covering all these parts. Remember, in the preamble, we will study in detail the word unity and integrity. Unity was already there, integrity was added. Then fraternity is there. Common brotherhood means fraternity. You will find these terms in the preamble itself. So, ours is a secular state. That means there is no official religion of the Indian state, and the word secularism has been added again by the 42nd Amendment. Though these features were already there in the Constitution of India, but this word in the preamble was added by 42nd Amendment. The secular state has no religion, no official religion, and everybody is free, has a fundamental right to either profess or to propagate a religion of his choice. And also that includes that even if you don't want to propagate or profess any religion, it is up to you. It's your fundamental right. So there is a complete separation between religion and the state. Like in Vatican City, it's a Christian state where church and politics and the governance is, the same. The church, the religion and the governance is same. In the case of Islamic countries, it is the same way. The religion and the governance are treated as this thing. They are same, they are related. But in the case of a secular state, there is a complete separation. So, equal respect to all religions or protecting all religions equally. This is what is guaranteed through fundamental rights in the Constitution. Now, universal adult franchise is another salient feature of the Constitution. That means the basis of elections to Lok Sabha and state legislative assemblies has to be through universal adult. Adult is the 18 years, which was changed in 1988 from 21 years in 1989, but the amendment was done in 1988, 61st Amendment. So, no discrimination, that is universal. Adult is here. Franchise is vote, that you vote if you are 18 years of age and above, and then there is no discrimination on that. Single citizenship, like I said, USA, you have dual citizenship, but in India, we have a single citizenship. The same political and civil rights of citizenship. If you are a citizen of India, you have the equal rights as given in the Constitution. Now, there are certain independent constitutional bodies which are created by the Constitution. One is the Election Commission of India, Comptroller and Auditor General of India, Union Public Service Commission, State Public Service Commissions. Now, Election Commission's duty is to have free and fair elections. Okay? Which is very important for any democracy. Comptroller and Auditor General of India has to check has to do the work of an auditor. That means to see whether the expenditure is done properly for the purpose it is meant. If there is a budget provision for spending on a particular function of the government, it has to be spent only for that, and that too without any violation of law, rules or regulations. This is their job. Union Public Service Commission, you very well know, you all are going to face them very soon to become the civil servants. They conduct various examinations. Same is the case with State Public Service Commissions. They conduct examinations for their state services. Now there are basically three emergency provisions: national emergency under Article 352, state emergency, that means President's rule under Article 356, or financial emergency under Article 360. These are three kinds of emergencies, and during emergencies, certain powers, extraordinary powers, are given to the government. So, we come to a very important aspect, that is the three-tier system of governance. One is the center, other is the state. What is the third tier? Third tier is the local bodies, like panchayatis, raj bodies. Okay, like you have the village panchayat, you have the Zilla Parishad. Like that, there are different tiers. Different systems have been adopted by different states in their respective states, but they were introduced through 73rd and 74th Amendment. So, a third tier of the government was added, which was the dream of whom? Mahatma Gandhi. So, we have panchayats in part 9, we have municipal corporation part 9A. That is in schedule 11, this is in schedule 12. Just for your knowledge that this is important, that the third tier of governance was added by these amendments. Now, cooperatives also have been added as a fundamental right and also a directive principle. So, through 97th Amendment, made three changes. One is the creation of a fundamental right to form a cooperative society. Then a directive principle to promotion of cooperative societies. And then these are the new parts which is entitled at what the cooperative societies will be. Have you heard of, to make the thing simple to understand, what are cooperative societies? Amul, Amul is very important, part of our lives now. Amul ghee, Amul paneer and milk products. How they procure milk? It all started in Anand in Gujarat. That's the headquarter of Amul also. How it started? Now they formed a cooperative society where the members were they used to produce milk. They used to procure milk. They were the producers. They had the milch animals and they used to produce the milk. Now this cooperative society, the key word is the cooperation. So each member was, contributing to the total kitty of milk. And whatever income is generated by sale of milk or milk products through various processes, after deducting the expenditures, that money goes to the members. So every member gets benefited. First thing is they don't have to search for their markets. Their product is sold at their own doorstep. It is collected from there. And then money is, after testing, it is graded and money is paid according to that gradation. So this is a very, very important aspect for a welfare state like India, which is primarily rural based. We have the predominantly India is a rural domination state where almost 80% of the population lives in the rural areas. So in that case, this is a kind of a boon to the poor people or those who are living in the rural areas. They don't have direct access to the market, and also they don't have to run from pillar to post to get their money. So this is a very important, inclusion, as this is how the welfare state works. It has been given a constitutional status, cooperative societies, through the constitutional amendment. Okay? By way of a fundamental right, by way of directive principle, and also creating a new part, Part 9B of the Constitution, which defines what are the cooperative societies. Now we come to a very important aspect, because we get, yesterday also I mentioned, we get questions as to critically examine this. A statement is given, critically examine. So same way, our constitution, having all the good salient features, is also subjected to criticism. So what that criticism has been, that it is a borrowed constitution, because we have borrowed certain provisions from various sources. So first criticism is that it is a borrowed constitution. Then it is carbon copy of 1935 Act, that we have just copied it from that previous Act of 1935, Government of India Act of 35. It is un-Indian or anti-Indian. What do they mean by that? Because we have taken various provisions from different countries with different ideologies, different political systems. So that is why they are not Indian. Okay? And un-Gandhian constitution, because at that time, the Gandhian philosophy was to have the three-tier system and give more powers to the local bodies. The third tier, but that was not there in the initial phase. Elephantine size, the huge size of the constitution makes it prone to litigations and different legal complications. Now, paradise of the lawyers. That means It is a legal document. It's the supreme law of the country. So wherever legal aspects are involved, lawyers have more say. The lawyers contributed in the making of the constitution, and also when any right is violated, we have to go to a lawyer, or for that enforcement of the right, for any judicial review, we have to go to the court where we may need a lawyer, though the courts say through public interest litigation that anybody can approach the court. Okay, but still the critics feel that this is a paradise of the lawyers. Now, once you write this criticism in your critical, face of the answer, you must also say that this is not exactly true. How? It is not a borrowed constitution. Why you say it is not a borrowed constitution? Because we have picked up the best features and we have made it, adaptable to our conditions. What we required, what were the aspirations and aims of the people. According to that, we have tailor-made it, customized it. It is not a carbon copy. We have picked up what essential features were required for the governance of the country according to the democratic principles and republican structure. It is not un-Indian. Why? Because, as I said, we have taken the features from other constitutions, but we have adopted to our own Indian conditions, customized one. Its size is big. We can't help it because we wanted to have the what? We wanted to have the best of the features. If we have to incorporate, the length has to be, it has to be the big size. Paradise of lawyers, now the things have changed. I said through PIL, anybody, even a letter can be sent to the Supreme Court, and that will be treated as a PIL, as a petition. So it's not only that. So that way, you must, if a question comes like that, critically examine, write all, but then give your own justification in a positive manner. Okay? So friends, with this, we come to an end of today's session on the salient features of Constitution of India. I have tried to make the things very, very simple to understand. Still, if you have any doubts or any questions, you are welcome. And one more thing, let me add that some of you have sent your handwritten notes to me, which I am going through. I have certain observations to make on that, and I'll be conveying to you individually, not collectively in the class, because I don't want to, discuss the negative aspects. Yes, if there is something extremely well written by somebody or well expressed by somebody, I love to, discuss here in front of everybody. But if there is a criticism, in that case, I'll confine it to that individual and try to make the corrections, okay, and suggest what kind of corrections are required, what is the best possible approach to address that particular issue or topic. Yeah, please. For tomorrow's topic, I have divided it into two parts because if I take only one part, then it will be over in a very short period because we are not getting into the legal details of that as per the syllabus of the law optional, but for general understanding. So I will be covering, I think, more than one topic tomorrow. So I'll request all of you to be there in time so that you don't miss out on anything and you don't have to go for the recorded version, because I would love to interact with you. Okay, friends. Amrita, if in case we are not able to hear you, you can send me your query in the mail and I'll answer that. And for others, I wish you all the best. Good night, and we'll see you tomorrow with our another session. Thank you very much.
For more videos, subscribe to N BY IAS and press the bell icon to never miss an update.